of TCC Judgment 113 宪判 2. Case on life sentence prisoner serving remaining sentence after revocation of parole. High notes. Article 79-1, paragraph 5 of the Criminal Code stipulated that the life sentence parolees who got their parole revoked have to serve a fixed remaining sentence of 20 years, 25 years under Provision 3. The provisions violated the principle of proportionality and individual liberty under Article 8 of the Constitution. Article 7-1, paragraph 2, 7-2, paragraph 2 of the Enforcement Law of Criminal Code, which stipulated that the calculation of remaining sentences should apply either Provision 1 or 3, depending on the time that the reason for parole revocation happened, does not pertain the principle of retro non-agent, that is, the non-retroactivity of the law, and the protection of illegitimate expectations. Background note. In 1997, legislators amended Article 77 of the Criminal Code, raising the parole-eligible minimum terms for life sentences to 15 years, 20 years for recidivists, to address the rise of the recidivism rate, including new offenses, among parolees. The legislators also added Article 79-1, paragraph 5 of the Criminal Code, stipulating that once the parole of life sentence parolees were revoked, they have to serve a fixed remaining sentence of 20 years, which should be discounted from the calculation of the next eligible parole date. The paragraph applies to parole revocation after the 1997 amendment. Said provisions were further amended in 2005, implemented on July 1, 2006, raising both the length of parole-eligible minimum terms and the fixed remaining sentence for life prisoners to 25 years. The parole has to serve a 25 years fixed remaining sentence without parole. In other words, the prisoner who started serving their sentence in 2006 must serve imprisonment until 2031 before starting serving a new sentence. After that, they must serve half of the new sentence before being eligible for parole. Summary of the judgment holding. 1. Provisions 1 and 3 stipulated that the life sentence parolees who got their parole revoked, hereinafter revoked life sentence parolees must serve a fixed remaining sentence of 20 or 25 years. The provisions designated fixed remaining sentences without distinguishing whether the parole revocation was caused by new offense or a simple violation of Rehabilitative Disposition Execution Act, that is a parole violation. The provision also did not differentiate between factors such as the circumstances and the severities of new offense or the effectiveness of the parolee's rehabilitation program. Within this scope, the disputed provisions violate the principle of proportionality and individual liberty under Article 8 of the Constitution. The provisions should cease to be effective after no more than 2 years grace period. Part 2. If the amendment of Provision 1 and 3 is past due, the competent authority shall decide proportionately the remaining sentences of the revoked life sentence parolees as provided in the judgment. A fixed term of 20 or 25 years is not required. Part 3. The final court rulings of petitioners number 5, 22 to 29, 31 to 35 were unconstitutional and should be quashed with their matters remitted to the Supreme Court. During the aforementioned grace period, the Supreme Court shall suspend the proceedings by ruling until the amendment may be made. If the amendment is past due, the Supreme Court shall decide the cases following this judgment. On its original case for this petition, the Supreme Court Criminal Panel number 1 shall also decide as such. Part 4. The Prosecutor General may lodge an extraordinary appeal upon the petitioner's application or ex officio for the remaining petitioner's cases. During the aforementioned grace period, the Supreme Court shall suspend the proceedings by ruling until the amendment may be made. If the amendment is past due, the Supreme Court should decide following the Part 2 of the holdings. Part 5. Life sentence inmates or other than the petitioners serving their remaining sentence under Provision 103 may file an objection against the prosecutor's order regarding carrying out the remaining sentence after the announcement of this judgment. The court should suspend and only resume their proceeding regarding the objection once the amendment has been made. If the amendment is past due, the court should decide per Part 2 of the holding. The same applies to the ongoing objection review of the same type. Part 6. If per Part 3 to Part 5 of the holding, the court shorten the remaining sentence and the new adjusted sentence is shorter than the period that the inmate has already served, the inmate should be deemed as having completed the remaining sentence from the day they have served and shorten the period and begun to serve their other sentence, if any, from the next day. There should be no ensuing criminal compensation, state compensation, or reduction of sentences for other crimes. I read it again. If per Part 3 to Part 5 of the holding, the court shortened the remaining sentence and then the new adjusted sentence is shorter than the period that the inmate has already served, the inmate shall be deemed as having completed the remaining sentence from the day they have served the shortened period and begun to serve their other sentence, if any, from the last day. There should be no ensuing criminal compensation, state compensation, or reduction of sentence for other crimes. If per Part 3 to Part 5 of the holding, the court shortened the remaining sentence, the new adjusted sentence is shorter than the period that the inmate has already served, the inmate shall be deemed as having completed the remaining sentence from the date they have served the shortened period and begun to serve their other sentence, if any, from the next day. There should be no ensuing criminal compensation, state compensation, or reduction of sentence of other crimes. Part 7. Provision 2 and 4 do not pertain to the principle of lex retro non-agent and the protection of legitimate expectation. The petitioner's complaint in this respect shall be dismissed. Part 8. The rest of complaint shall be dismissed. Reasoning. Part 1. Parole's purpose and the constitutional rights involved. The parole system's purpose is to actively rehabilitate. The parole system's purpose is to actively rehabilitate inmates who have shown repentance and are legally eligible for parole by suspending the serving of their imprisonment. Once the competent authority approves a parolee will be discharged from prison as the sentence enforcement is on hold. Should the governing authority revoke its decision and reinforce the remaining sentences, it not only directly restricts the parolee's individual liberty, but also severely impacts the various rights and interests enjoyed by the parolee since his or her reintegration into the society. CJ1 interpretation number 681. I read it again. This is very important. The parole system's purpose is to actively rehabilitate inmates who has shown repentance and are legally eligible for parole by suspending the serving of their imprisonment. Once the competent authorities approves a parole, the parolees will be discharged from the prison as the sentence enforcement is on hold. Should the governing authority revoke its decision and reinforce the remaining sentences, It not only directly restricted the parolee's individual liberty, but also severely impacts the various rights and interests enjoyed by the parolee since his or her reintegration into society. CJ1 Interpretation number 681. Although the effect and execution of revoking parole do not amount to a new criminal sentence, requiring the parolee to return to prison and carry out the remainder of his or her sentence is still a form of constraint on individual liberty. Per the protection of individual liberty under Article 8 of the Constitution, such measures shall conform with the Article 23 Proportionality Principle. Part 2. The serving of the remaining sentence for the revoked life sentence parolees shall be proportionate. The revoked parolee must return to prison for institutional treatment, resulting in the deprivation of individual liberty. Although the sentence served after parole revocation comes from the remainder of its original sentence, it is still compulsory punishment that should be the last resort. It is still compulsory punishment that should be the last resort, and should be limited strictly. The calculation and execution of remaining sentence for revoked life sentence parolees should conform to the principle of proportionality, so that the constitutional right of individual liberty is not deprived excessively. I read it again. The revoked parole must return to prison for institutional treatment, resulting in the deprivation of its individual liberty. Although the sentence served after parole revocation comes from the remainder of its original sentence, it is still compulsory punishment that should be the last resort and should be limited strictly. The calculation and the execution of remaining sentences for revoked life sentence parolees shall conform to the principle of proportionality, so that the constitutional right of individual liberty is not deprived excessively. Part 3. Proportionality review of Provision 1 and 3. The purpose of the Provisions 1 and 3 are legitimate. The legislature amended Provision 1 and 3 alongside Article 77 of the Criminal Code in 1997 and 2005. The provisions regarding parole eligibility, grace, revocation, and ensuing effects were amended to address the increasing recidivism rate among the parolees. The legislators hope that doing so may fulfill the prison's correctional function and ensure that the rehabilitation of inmates and further safeguard the safety of society. It is fairly legitimate to heighten the parole-eligible minimum term to prevent life sentence parolees from committing major crime during parole. In correspondence with the adjustment, the legislature amended Provision 1 and 3, clarifying the specifics of the remaining sentences to be served for life sentence parolees after being revoked. The remaining sentences are 20 years under Provision 1 and 25 years under Provision 3. Both periods shall be discounted from Article 79-1, Paragraph 1, calculation for the next eligible parole day. Nonetheless, the Provision 1 and 3 still serve the purpose of rehabilitating inmates, preventing recidivism, and safeguarding social security, which are legitimate and important public interests. It is unnecessary Provision 3 to require a fixed remaining sentence of 20 or 25 years after parole revocation. Within statutory limit, including consideration of mitigating factors, the sentencing for the offenders culpable offense is based on the circumstances demonstrated at the time of sentence. In this respect, factors such as retribution and prevention purposes and consequently correctional period estimated in prison have all been considered when the court sentenced imprisonment. Since criminal punishment has a retributive and deterrence purpose, its sentencing and execution should be necessary to achieve the purpose. Since criminal punishment has a retributive and deterrence purpose, its sentencing and execution should be necessary to achieve the purpose. Such a requirement for necessity reflects on the lighter treatment, e.g. parole, that may be granted in lieu of imprisonment based on rehabilitation progress, and whether punishment served so far has done justice to the offense. For example, the full length of the imprisonment sentence may be shortened depending on the inmate's performance and the correctional result under the statute of progressive execution of penalty. Considering the necessity for the punishment to achieve its purpose, the rehabilitative potential of the sentenced person, parolees, shall be re-evaluated in light of all the circumstances prevailing at the time of parole revocation. Subsequently, within the scope of the remaining sentence length and at the time of the parole, the length of the remaining sentence after parole revocation must reflect the time needed to achieve the punishment's special deterrence purpose. Instead of ordering a fixed remaining sentence regardless of the circumstances involved, such consideration shall also apply to life sentence parolees who got their parole revoked. Provision 1 and 3 stipulated the length of remaining sentences for revoked life sentence parolees, aiming to realizing the purpose of punishment. Such remaining sentences are the continuation of the pronounced life sentences in cases where the parolees committed a new offense or violated probation terms during their paroles. Re-entry into prison may be necessary. In cases where the parolees committed a new offense or violated the probation terms during the parole, re-entry into prison may be necessary. However, probation is a kind of community-based treatment for offenders or juvenile or pre-delinquent that aim at repentance and reintegration with the society through supervision, correction, and counseling. A simple violation of probation is distinctively different from committing a new crime intentionally, in which the latter causes direct harm to others' rights and destroys social order. The two must be treated in different degrees regarding the remaining sentences. Circumstances of intentionally committing a new crime may differ. The necessity of continuing the sentence is different in each case. Factors such as the reason for parole revocation, the time served, and evidence of repentance that support the parole, and the parolees' efforts made for reintegration, and the possibility of recidivism, etc., shall be assessed comprehensively to conform to the necessity of punishment. It is only equitable to treat the cases per their respective circumstances. Otherwise, it would violate the principle of proportionality. However, provisions 1 and 3 require a fixed remaining sentence of 20 or 25 years for revoked life sentence parolees without considering the circumstances of each case, which would deprive the parolee of the opportunity for such a reassessment. There is a possibility that the revoked parolees will serve a length of the sentence that exceeds the necessity. Within this scope, the provision violates the principle of proportionality and subsequently infringe on the people's individual liberty under Article 8 of the Constitution. The provision should cease to be effective no more than a 2-year grace period. If the amendment is past due, the competent authority shall decide the remaining sentences following this judgment. The length of such a sentence should be proportionate instead of a fixed one. The competent authority may refer to the following guideline and decide the remaining sentences per Part 1 of the holding. For parole revocation under Article 78, Paragraph 1 and 2 of the Criminal Code, the remaining sentence shall be decided based on the sentence length of the new crime committed during the parole. When the new crime sentence length is under 5 years, the revoked parolee shall serve 10 years for the remaining sentence of the life prisoner. New sentence length above 5 years but under 10 years, the remaining sentence shall be 15 years. New sentence length at 10 years or over, the remaining sentence shall be 20 years when applying Provision 1 and 25 years when applying Provision 2. For parole revocation under 74-2 and 72-3 of the Rehabilitative Disposition Execution Act, the remaining sentence shall be 5 years, except when the parolee is convicted of a new crime committed during parole. The remaining sentence shall be adjusted per Guideline A. The final court ruling of petitioner Number 5, 22, 23, 24, 25, 26, 27, 28, 29, 31, 35, which apply Provision 1 and 3, contravene the Constitution. The ruling shall be quashed with the matter remanded to the Supreme Court. During the grace period for the amendment, the Supreme Court shall suspend their proceeding until the amendment may be applied. If the amendment is past due, the Supreme Court shall decide per Part 2 of the holding. Supreme Court Criminal Panel Number 1 shall also decide the petition's origin case following the holding. Part 5. As for the final court ruling of the petitioner other than those mentioned in Part 3 of the holding, the Prosecutor General may lodge an extraordinary appeal as official or upon petition under Articles 91, Paragraph 1 and 2 of the Constitutional Code Procedure Act. As for the final court ruling of the petitioner other than those mentioned in Part 3 of the holding, the Prosecutor General may lodge an extraordinary appeal as official upon petition or upon a petition under Article 91, Paragraph 1 and 2 of Constitutional Code Procedure Act. During the grace period for amendment, the Supreme Court shall suspend their proceeding until the amendment may be applied. If the amendment is past due, the Supreme Court shall decide per Part 2 of the holding. Considering the protection of individual liberty and the uniform application of the law, inmates currently serving the remaining sentence under Provision 1 and 3, which are declared unconstitutional, shall have the opportunity to adjust their sentences under amended law. After this judgment, if the inmate file an objection against the prosecutor's order to serve the remaining sentence, the court shall suspend the proceeding until it may apply the amended law. If the amendment is past due, the court shall decide per Part 2 of the holding. The same apply to ongoing objection review of the same type. Part 7. Requiring revoked life sentence parolees to serve remaining sentence align with the principle of proportionality under Article 23 of the Constitution. The unconstitutional fixed sentence under Provision 1 and 3 can be cured. Requiring revoked life sentence parolee to serve remaining sentences align with the principle of proportionality under Article 23 of the Constitution. The unconstitutional fixed sentence under Provision 1 and 3 can be cured by offering the opportunity to adjust the remaining sentence per Part 2 of the holding or amending the law. The effect of the period already served shall not be altered. After adjusting the proper length of the sentences, inmates who consequently serve time longer than they should have shall be considered completing their sentences. Their remaining sentences shall end on the last day that they actually serve. They shall continue serving They should continue serving time for their other crimes, if any. There should be no ensuing criminal compensation, state compensation, or reduction of sentence for other crimes. Part 8. Provision 1 and 3 have more severe effects on revoked life sentence parolees compared to previously implemented regulation. Under Provision 2 and 4, whether the new law applied should be decided based on the time that the reason for parole revocation happened. Provision 2 and 4 did not enable Provision 1 and 3 to be applied retroactively to the fact that they had happened before the implementation. Provision 2 and 4 did not enable Provision 1 and 3 to be applied retroactively to the fact that had happened before their implementation. Provision 2 and 4 do not concern the principle of lex retro non-age and the protection of legitimate expectation. The petitioner's complaint in this respect should be dismissed. Under Provision 2 and 4, whether the new law applied shall be decided based on the time that the reason for parole revocation happened. Provision 2 and 4 did not enable Provision 1 and 3 to be applied retroactively to the facts that had happened before their implementation. Provision 2 and 4 do not concern the principle of lex retro non-age and the protection of legitimate expectation.